Donald Trump demanding subpoenas to get access to those missing January 6 records. And this is Judge Chutkan's courtroom. So we're going to go through two filings today. The motion for the pretrial subpoenas that Donald Trump's team has submitted as a reply. And we'll see if the judge issues a ruling on this because we want those records. And we're also going to see that Judge Chutkan denied Trump and his defense team access to some very important documents that Trump's team has not even seen yet in filings that have already made their way to the judge. In other words, Jack Smith is being allowed to send the government materials that nobody can see and that Trump's defense can't even see because this is a show trial that's taking place in America. Now we're going to go through both filings, but let's start off with the subpoenas because boy, we like when we get some subpoena activity. And Trump's team filed the following. It's 7 pages and you can see it is submitted as a reply, which means this is Trump's final word to get these subpoenas authorized, telling the judge, Your Honor, President Trump has already moved for permission to get pretrial subpoenas to force the production of records aimed at recovering documents and recordings that the January 6th Select Committee did not properly archive. They have records that are missing. We need them. They have not given them to us, and so we're going to have to get a subpoena, including video recordings, records that the committee transferred to government agencies on the last business day. So Liz Cheney's committee gave to someone else before they dissolved it. Trump is seeking these records concerning the disposition of these missing materials. They say, apparently, Your Honor, apparently concerned that these missing records would be helpful to the defense or detrimental to entities acting in concert with the Biden administration, the Jack Smith prosecution goes to great lengths to resist the production of these materials. And they make various claims, incorrectly, that the requested records are not sufficiently relevant, they're not specific, or they're not admissible. And so despite claiming that the requests are not sufficiently described, the prosecution and Jack Smith and these deranged thugs over there strangely and they falsely claim that President Trump already has access to the materials that he seeks. And so these objections are meritless and Trump's defense is going to go through each one of them in turn, making the argument that they need those subpoenas to go get those missing January 6 records. But before we get into the rest of this, a quick message from our friends. Now, we're back with the motion from Trump's defense. And the first area that they're going to attack, they're going to say that we need these missing January 6 records because our request was specific. We're not just asking on a fishing expedition to go get missing documents just in hopes of finding something. We know what we want. And we know that if a subpoena is not specific, it might fail. But these records meet the threshold. They say Trump seeks records concerning the disposition of these specific records, the loaned and the now missing committee records. And we remember what happened. They were just bundling these up, having people sort of redact and delete portions that they didn't want before they became archived. They say the committee, undoubtedly, Liz Cheney and Crying Kinzinger's committee, would not have given control of the records to other government parties without discussing the matter internally first. And likewise, the committee, the J6 committee, almost certainly communicated with agencies that took possession of the missing records. So they know where they went. And so the subpoenas request only these communications about where the documents went, where they ended up, to whom they landed, and so on. They're specific, they're highly relevant, they're not overly broad, and they lead to an understanding of why the committee tried to conceal these materials. Why did they just get deleted? And Your Honor, the letters state that all or most witnesses and their interviews were recorded. So when Liz Cheney was bringing people like Clavicle Girl around into their offices, they recorded them. The video recordings of the transcribed interviews and the depositions, which were featured during Liz Cheney's hearings, were not archived or transferred to the House Administration Committee. Why didn't they save the depositions and the interviews, the videos? Why not? It's a cover-up of epic proportions, noting that the committee did not archive all video recordings of the interviews or depositions because they were not useful to them. Trump seeks these recordings, Your Honor, and we need a subpoena to do it. It is hard to imagine a more specific request than that. Now, they say that the government claims that we've already produced some of these materials. Deranged thugs have, but carefully declines to say whether it has produced all of them. And to the extent that it has, President Trump invites the prosecution to identify the records with particularity and to verify that they have in fact produced all the materials that the committee, quote, loaned to any government entity. Now, of course, the contents of the subpoenaed tapes could not at that stage, now this is a quote from another case, they say, Your Honor, Chutkan, in fact, it should be trivially easy for the government to locate and produce the recordings of the January 6th committee and what they created of the witness interviews in the ordinary course of business, presuming, of course, should be very easy. Okay, this is the government. They should have all of these records. That the committee did not delete the recordings specifically to ensure that President Trump and other political opponents could not obtain them, which appears likely. And that would be, in my argument, we'll see if they get there, the deletion of exculpatory evidence, which should result in a sanction against the government, leading to the dismissal of the entire case, right? If they're deleting evidence that might exonerate your side, that's in the government's possession, and they're not providing it to you, I would argue for a dismissal on that. I'm sure they will. Now, they're still trying to say that we should get this stuff first. They're going to try to get it, right? That's several steps down the road. Get a subpoena, give us the materials, let us investigate it. When we can't get it, or we try to get it and it's not there, boom, that's the motion to dismiss for that basis. Now, in sum, Your Honor, Chutkan, the requested subpoenas here in no way resemble a fishing expedition. We're not just throwing a shotgun approach out here. The kinds of documents that Trump seeks are narrow. They're specific. We want video recordings of witness interviews, the records that the committee shipped out the door just before shutting down. And we want the correspondence related to the same. Who got the records? Where did it go? Follow the chain of custody. Saying, Your Honor, based on the 4 letters attached as exhibits, these are the records respondents would be aware of and can easily locate. Indeed, the records were significant enough to engender a dispute among members of Congress about their disposition. And Nixon, in a prior case, in the specificity prong, here is satisfied from that case. So we have satisfied that request for our subpoena. Okay, a subpoena has to have specificity to it. The subpoena has to have relevance and these other factors. They say, Judge, by the way, this is very relevant. You know why? Here, the committee materials, and especially those that were transferred to government agencies in some procedural trick to avoid their archival, are manifestly relevant to this case. Trump, in this case, is being prosecuted for January 6th, the so-called insurrection. And here, the committee's entire purpose was to investigate the events alleged in this indictment. And conceding the obvious relevance of that investigation, the prosecution here, Jack Smith's deranged thugs, has produced large quantities of the committee material in discovery. Okay, so Liz Cheney and the fake illegally constituted select committee were like the first version of a grand jury that's been impaneled to investigate a crime, but they did it politically, openly, in front of all of America, bundled the whole thing up, and then just delivered it over to Jack Smith. It's wild what's happening, but they did it. So 2, should President Trump have the right to obtain the vital committee records? If they're going to give some of those records, we should have all of them. Saying that the committee tried to segregate those materials and they tried to avoid archival and then later the production. They deleted them. And they give us some examples. They say, Your Honor, Jack Smith's thugs are saying that they don't actually need to deliver the video recordings because they're superfluous, because the videos are not needed because they're big files. You know how much data a video can take? It's a lot. You don't want to save all those hard drives. And they say, so we just have transcripts. So transcripts is enough. Wrong. They say not so. First, video conveys far more information about a witness's demeanor, tone, and expression than just some regular witness transcript. And second, many of the transcripts produced by the committee, they're not signed, they're not otherwise adopted by the witness, meaning that the recordings will be essential to establish their authenticity and will also be needed as impeachment evidence if some witness denies making those statements. And we've made this point too. Like if you look up Ray Epps' depo, his transcript of his interview, it's like a joke. They don't even tell you who's speaking. There are run-on sentences. Like an automated transcriber could have done better. They got some kid who's just brand new to typing class and they're like, hey Johnny, can you come over here and practice your typing skills for this very important congressional meeting? He's like, yeah, Aunt Liz, I'd love to. So third, notwithstanding the committee's footnotes that nonpartisan professional official reporters produced the transcripts, no, definitely not. Okay, they were garbage. It provides no indication who these individuals are. Exactly, it was Johnny, who's 9 years old. And many transcripts do not even say. Thus, many transcripts lack the typical markers of authenticity on their face and may never be authenticated. And fourth, many interviews took place via WebEx and other methods. It appears that numerous transcripts were not created in real time by a court reporter sitting in on the interview, but they were reviewed after the fact from the videos that Trump now seeks. Okay, so there wasn't an actual court reporter. They're like doing it in reverse. This presents a best evidence problem. Okay, we don't want their transcript. In other words, they have the videos, and when they request the videos, they then transcribe the videos and give them the transcripts. And they say, no, we want the best evidence. Give us the videos. Don't give us the transcript of the videos. And a court reporter transcript of a video is not a substitute for the video itself. And this is what is so gross about all of this. If Trump is such an insurrectionist, why don't they just publish all of it? Why'd they delete any of it? Because they know it's fake. We know it's fake. They also continue. They say, for example, President Trump is entitled entitled to all the evidence regarding widely reported decisions made by Nancy Pelosi and Mayor Muriel Bowser, who specifically declined to have the National Guard come. That was authorized and made available by Trump on January 6, even if the committee wrongfully disposed of those materials before disbanding. You're saying Trump committed an insurrection without charging him with that. So we want to know what Nancy Pelosi was doing, and Muriel Bowser as well. Finally, Your Honor, the requested subpoenas seek information that is relevant to motions for spoliation of evidence and due process violations based on unlawful coordination between Jack Smith, NARA, the committee, and others. And this is going to be another issue that explodes. The idea being that the documents were not illegal, then there was a request to make them illegal, then NARA reclassified them to make them illegal, and then Trump got indicted because the documents were reclassified as illegal. Now, they continue. The fourth prong, Judge, why we should get subpoenas for this, which I'm sure she'll deny, says the requested records could be admissible as public records. All these reasons why we could admit these, okay? Like they're not going to be not admissible. Give us a subpoena and we're going to be able to use them. They're not going to be precluded. We can use them as public records under 8038. We could use them to refresh a witness's recollection under FRE 612. They could be admissible under the residual clause under FRE 807. We could serve as impeachment materials under Nixon and others. A lot of different ways we could use them, so therefore they are admissible. And finally, Your Honor, they say President Trump has a constitutional right here to due process, to fair trials, to the right to have counsel, and to get evidence. So counsel has the right to go and get a subpoena to require people to compel to evidence, to produce and compel them to produce the evidence, saying that Jack Smith and those deranged thug prosecutors and their resistance to the requested subpoenas is emblematic of the injustice that pervades this case. First of all, they're not giving us the material, and they're fighting us when we want to go get the material. Like, these are prosecutors. If Trump is dead to rights in this case, they should just give him everything because he insurrected us so badly. But why are they deleting evidence from the defense? Trump, at the prosecution's request, has been repeatedly and unlawfully deprived of a fair and meaningful ability to defend the charges against him and to prepare for trial. He can't even read the evidence. So there's like 8 or 12 Washington monuments worth of evidence now. His attorneys made the argument it's like reading 70 copies of War and Peace every day per attorney or something. It's insane. So the prosecution is now opposing these subpoenas. It is the latest effort by them to impede Trump's right to a fair trial. They don't even want him to get the evidence that he needs. So, Your Honor, they say, permitting Trump to gather this evidence before this trial such that the defense may fully review these materials and incorporate them into their strategy implicates the core of the Sixth Amendment right to the effective assistance of counsel. Your Honor, we're the lawyers and we can't do our job if you can't allow us to go get evidence that we need to do our job. So saying ultimately, the Constitution guarantees Trump a fair opportunity to review the discovery, to compel the evidence, and to prepare a defense. And so without the request of the subpoenas, this guarantee that Trump is guaranteed under the Constitution will be undermined, and so the court should grant our requests and issue the requested subpoenas. That's the final word from Trump's defense, and we're going to watch the judge deny these subpoenas, and I'm sure she'll explain that it's duplicative, it's not necessary, she can't make the government do certain things. We'll probably see a separation of powers argument in there and other nonsense. You probably saw this story about Chicago BLM supporting the attack on Israel with a very provocative X post. The title, Fury, as Black Lives Matter group posts image of paratrooper and says it stands with Palestine. A lot of people on the right were talking about this story, obviously, but on the left, total silence. When we look at the story over on Ground News, the sponsor of this video, we can see that there are currently more than 20 stories published about this, and over 90% of them were from the right. That makes sense. The right is indulging in the left's hypocrisy while the left is trying to ignore it. We can also see every article published on this topic in one place and compare each headline to see how the media is framing the story. What's nice about the Ground News app and their website is that it aggregates all the news sources from local and international sources on any given story, and it shows us who is saying what, and it even provides background information on the news sources themselves, like who owns them, and it gives us their factuality rating and their political leanings as well. But what I love most about Ground News is their blind spot feature, and maybe even more importantly, shows the stories that the right might be missing or even hiding themselves, stuff that we don't want to ignore and that we need to cover here. We have our opinions on this channel, of course, but we try to make sure that we know what the other side is doing, because that's how we make our arguments stronger. Ground News helps with exactly that, which is why I think what they're doing is more important than ever. So check check it out for yourself. Go to ground.news/RGE. I really believe what they're doing is important, so check it out. The link is down in the description below. And so we, of course, will continue on. We've got Judge Chutkan, who in addition to very likely denying those subpoenas, and we'll see if Trump does something about that, but also is denying Trump's defense access to information about what the prosecutor is sending to the judge. I know that sounds convoluted, but let's walk through this. Chutkan is also now denying Trump's request to see some of the classified information that is being used in this case against him. So Trump not only may not have the opportunity, the permission to go track down evidence via subpoenas, but the government can also hide things from him under the SIPA rules, Classified Information Procedures Act. Let's watch. This is the opinion in order. This is coming from Judge Chutkan herself out of the District of Columbia. She says, all right, everybody, both sides, Trump and deranged thugs. Before the court are two motions. First, the government, deranged thug Jack Smith, they submitted a classified, it's called an ex parte, in camera, under seal motion for a protective order. Now, a lot going on. Ex parte means that they're not notifying Donald Trump's side about it. Okay, they're not showing the other side. Normally, you show the other side. Do you agree with this? Do you have a position on this? Do you object or not object? Do you take no position? But they're just submitting this without even telling Trump what they're submitting. In camera means that they're asking the judge to look at it behind chambers, kind of, off the record on her own. So that's not even a part of anything officially. In cameras, behind closed chambers, in the judge's chambers, off the record, off the floor of the court. And it's under seal so that it'll officially never be a part of the record. And what they're asking for is a protective order. Okay, so that protective order is presumably going to go and protect against something. And typically, as we've seen in this case, that means that Trump is being limited. Okay, they are protecting the court system against Trump. That means Trump gets gagged, Trump can't do certain things, Trump can't communicate about certain things, Trump's lawyers can't communicate about certain things, they can't even notify the press about certain, like nothing. Like, do you see how many layers of seal this is? Trump's people have no idea what's going on, like at all. And so the government filed it, and Trump's people knew about like that filing, but other than that, there's nothing in there. They just know that it exists. So Trump submitted a motion for access to the filing, right? Trump said, okay, the government is asking for a protective order that Trump can't see. They did disclose that they filed the motion, and so Trump responded and he said, hey, we want access to that thing, a motion for access to the filing. So the judge says, sorry, no access. I am going to grant the government's motion, which gives them a protective order over the defense that presumably Trump has not seen. It's been filed under seal in camera, ex parte, and it's classified, okay? And they're going to deny Trump's request for access, so he can't see anything. Do you see what kind of a psycho government this is? What kind of a psycho, like, we read about this in the Count of Monte Cristo, when Edmond Dantes was locked away, and they said, what are my charges? What are my crimes? Can't see any of it. No idea. Whatever they say it is. So the judge is going to keep Trump's defense in the dark. They say the government's motion requests that the court, pursuant to SIPA, conduct an in-camera, in-chambers, ex parte, outside of Trump review of the government motion. They've got declarations in there. They've got exhibits in there. We can't see any of it. Neither can Trump's defense. Okay, like I would understand if we can't see it as the public, but Trump's defense could. Not even Trump's defense can see it. And two, they also want to authorize the government to withhold from discovery certain classified info and provide an unclassified summary substitution for certain classified info. Okay, so they're just going to say, Trump people, you just get like a nice little blurb that's totally unclassified, and we don't have to give you any of it. They're also granting order that the entire text of the government's motion, so everything in that filing and the accompanying declarations and exhibits, all of which are classified, shall not be disclosed to the defense and shall be sealed and preserved in the records for the court to be made available during a future review of these proceedings, burying the whole thing. They say the court has carefully reviewed the motion from Jack Smith and the declarations and exhibits, and we conclude, says the judge, that it was properly filed ex parte and in camera and under seal. Says initially, the court finds that the classified information referenced in the motion implicates the government's national security and their classified information privilege, right? The government has the privileges. Accordingly, the information is only discoverable to the extent that it's relevant and helpful to the defense. And the judge says, well, I reviewed it, and based on its review, the court, and its discussion with the defense counsel during a recent ex parte hearing, the court finds that the government's proposed summary of the classified information adequately describes what Trump and his defense team are going to need. And that's it. As a result, the motion satisfies satisfies the standard and provides good cause for withholding those materials. So government is granted. Now, Trump and his attorneys, they say, well, how about we can just see it? Can we have attorneys' eyes only to what you're trying to do so that we can at least see what your arguments are to the court? They say the court has discretion to give us access to that, and they made their arguments. But at the outset, the judge says it bears emphasis that the defense identifies no case in which any court has ordered the relief that they received, and this court is aware of none. Isn't that interesting? Do you know why, Judge Chutkan, do you know why there's no precedent for a case like this? Because it's never happened before. Gosh, the court is aware of none. Guess what? There isn't any precedent because a president has never been prosecuted in a kangaroo show trial court like this. There is a good reason for that lack of precedent, as they say. The House report explains, since the government is seeking to withhold classified info from the defendant, an adversary hearing with the defense knowledge would defeat the very purpose of the discovery rules. And in any event, they say it's not possible to isolate, in other words, they've written the rules to support the fact that they don't have to disclose things. Like the government and the intelligence agencies have created a law that protects them because that's what they do. So she says, in any event, it's not possible to isolate the unclassified portions of the motion in a way that could meaningfully be litigated. So it's too sensitive for you guys to see what we're doing to your own client. Now, the judge says, as you might expect, the government's discussion of legal principles is sufficiently interwoven with the evidence. So even what the government is asking for is so intertwined with the evidence in the case that we can't even tell you what they want. So the judge says, rather than take this unprecedented and likely futile course of trying hopelessly to unentangle these things, what I decided to do is hold an ex parte hearing with the defense counsel to see whether this would be relevant. And when we were there, they said the presumption against ex parte proceedings, we don't like it when one side talks to the judge. That is insane. Like, that's not fair, is it? No. Both sides should be able to talk to the judge and get both sides in, but that is not happening here. The defense may be right, saying, well, one side is granted or graded access, but on their face, those points contrast rather than compare the SIPA regime, which expressly, like, the judge is deferring to the law. She says the law says if it's classified, we can do ex parte proceedings. And I don't care if you have security clearances, you're still not entitled to see this stuff. So none of these points make me want to deviate from ordinary SIPA procedures. And so that's what I'm going to do. Unlike other sections, I don't have to follow this. The sole case cited by Trump, which again, Trump can't cite any cases because no president has ever been prosecuted before and gone through this. And so they identify no court since that time. And so this court is not going to be the first, but of course this court will be the first doing a lot of other things. And so for the reasons as articulated by the judge, the government's motion to hide evidence and to seal evidence and to secretly talk to the judge is granted. Trump's request to take a look at the evidence is denied. The government is now authorized, according to Judge Tanya Chutkan, our American government, so-called, of justice, now has permission to withhold from discovery the classified information in its motion and to provide some unclassified summary to Trump's defense. And all of the materials, all of the motions, the memo, the exhibits, all of the additional documents shall not be disclosed to the defense. They shall be sealed and maintained in a storage facility under security of a classified information security officer for review when appropriate. So Trump, once again, gets no evidence at all because that's just what they do. They're cheaters. They hide evidence. They don't want the public to see any of this because what they're doing is, in my humble opinion, unconstitutional and illegal and unethical and disgusting and antithetical to American ideals. But that's what's happening in so-called courtroom in America. Judge Chutkan, very likely to deny the subpoenas. Now, we're going to continue to cover it, and we know Trump is going to be appealing a lot of this stuff because there will be collateral consequences that will impact the election if he doesn't win on some of these issues. We'll continue to cover it, my friends. Thank you for subscribing, and really thank you for sharing this. You know, I don't think that many people know about what is happening. Like, how can you have a justice system if a defendant cannot even see the evidence that is being lodged against him in the process? Reprehensible. We'll continue to cover. Thank you for inviting somebody to come here and join us, and we'll look forward to seeing you on the next one.